regarding class actions. I asked you to please look at Musa's case, but let's take 2 steps back. What is the meaning of standing? What is the question that we answer when we ask whether someone can stand? All together now, is the person before the court the appropriate person to bring the matter to the court? Okay? And at common law, we had a narrow definition, and we wanted the direct and substantial, or direct and sufficient. Okay, direct and sufficient interest in the subject matter of the litigation and the link between the person and the remedy that is sought. However, when it comes to public law matters, particularly the protection of fundamental rights, there's a recognition that we have to have a much wider approach to the protection of rights. And that wider approach is in order to make sure that the rights do not only stay on paper, but that they are actually relied upon and used. And what are the 2 requirements? In the middle of the night, I'll wake you up, but if I do, I won't blame you if you punch me first. But if I wake you up, you will look. An allegation that a fundamental right in the Bill of Rights has been infringed. Secondly, the efficient interest in the remedy that you seek with reference to the categories. Okay, and we have dealt with A and B yesterday, and today we're going to do at least C and D. And C and D are the most complicated. We have to get our heads around C and D, because if I'm going to ask you a question about standing, and I'm very inclined to do that, given the fantastic crop of today, then we will probably look at C and D. Okay, so we are talking about a class action, class litigation, or representative action. Now, what I want you to look at very carefully is the wording of the Constitution. It says, persons acting as a member of a group or a class of persons, and if you go back to the actual text of the Constitution, it does not require that person to be a member of the group. Let's go back to that. It is slide, oh, for goodness sake. Slide number 7. Okay. Anyone acting as a member of or in the interest of a group or a class of persons. What do we see here? We see that it is possible that I am a member of the group, or that it is possible that I'm not a member of the group, but I'm still acting in the interest or on behalf of the group. So it's not a requirement that the person who is bringing the litigation must actually be a member of a particular group. But let's go back to the discussion of a class action. Okay. First of all, what we have to bear in mind here, and Musa's facts are really interesting and appropriate to illustrate the point. Who can tell me very briefly what gave rise to the litigation in Musa's case? Hugh.
In 96, a whole swathe of people in the Eastern Cape, their disability grants were cancelled.
Okay. So, and the reason for that is historical. Simply for those of you who weren't in ESSA at the time, but please tell me you were in ESSA. Were you in ESSA? Were you people up by 1996? You are not serious. Were you not human beings in 1996? I think that someone's just driving to some place. It's ridiculous. I think that I talk about 1996 and everyone's like, oh yes, I remember the music that was quite shizzle. And okay, I apologize. But yeah, 1996, the height of grunge, I see that grunge is making a small comeback. I've got lots of tips on how you have to tie your dot martens if you want to know. But okay, let's get back to the reality. So in 1996, this is 2 years after the advent of constitutional democracy, there were in the Eastern Cape multiple departments paying out disability grants and old age pensions. Because we had the Transkei, we had the Ciskei, we had
the Department of Welfare for white people, for colored people, for Indian people, and this myriad of different departments orchestrating and actually dealing with exactly the same thing, but for different people categorized in accordance with race. Now, obviously, 1994 clearly signaled the end of a system like that. So the Department of Welfare of the Eastern Cape decided, okay, we need to streamline this. But they went a little bit in an odd way about it, because what they decided is, okay, we're just going to cut all of these, and then we're going to redo it all. Okay? But not bearing in mind what is the incredible impact on people who are completely dependent on their old age grants, on their disability grants, and a variety of other social security payments. So the important thing was this decision, and I mean, I'm not for a second think that it was a decision taken out of, I mean, Judge Cameron seems to think that it was malicious, but I think there was an attempt to say, okay, because it was possible to claim in the Cape Province, and then to claim in Transkei, and then to claim under another system as well. So there were a lot of ghost pensioners. So people collecting 3 pensions from 3 different departments. And I mean, obviously that's not in the interest of good governance, because if you're entitled to a pension, you're entitled to 1 pension, not to 3. You can't jukes the system, because if I jukes the system, everyone else jukes the system, and then in the end, we have no money to invest in infrastructure, education, blah, 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 blah. So, it was an attempt to clean up the administrative side of things. So they stopped all the payments. And the payments affected tens of thousands of people in the Eastern Cape. Now, each of those people had a claim against the department. So each of the 10,000 people could come individually and institute proceedings against the department. Obviously, there were attempts to engage in negotiation with the department beforehand, and the Legal Resources Centre here in High Street played a very important role in this whole facilitation process. But the important thing is that if you have a class action or class litigation, you have a single suit, and you catch all of the people who share the characteristics of the class under the same action. And the court order binds everyone. That's very important. But now the question is, how do we define who is in the class? How do we determine who is a pensioner in the Eastern Cape? And what if I am one of those people who actually had 3 pensions, and I don't really want people to find out that I have 3 pensions? And I don't want to be part of this litigation, because if they start digging, they might find stuff about it. How do I associate or disassociate myself with class litigation? Now, the important thing is, and this is an important procedural step, and if you read Musa, you will see it. You start by going to court and saying to court, here we are, pensioners in the Eastern Cape. Mr. Musa is one of us. He's a typical example of us. Please grant him the opportunity to bring the case on behalf of all 10,000 of us. So then the court will say, this is the class, and it will give the characteristics of the class. And then there's an obligation on the person who's bringing the litigation to advertise that. So that if I do not want to be part of the class litigation, I can write a letter and I can say, please, I'm a pensioner, but I'm not part of your group. I want to bring my own suit against the department. So there's 2 very clear stages in class litigation. Asserting standing through a certification process, and then secondly, dealing with the merits of the case. Now, our focus is at this point in time dealing with the certification process. Who is a member of the class? How do we set the parameters for the class action? Now, you may not know, you didn't do that as part of your civil procedure in your first year. But if I have a claim against the bank because they overcharged me interest on a loan, and you have a similar claim, and you come to know that I have a claim against the bank, you can formally apply to join that action that I have against the bank. So you can see where you have 10,000 people, it is possible to have 10,000 joiner applications. But how long will 10,000 joiner applications take? A very long time. So the class action is a mechanism to smoothen and streamline the process of dealing with multiple cases at the same time. Okay. So what happens then is that we say pensioners in the Eastern Cape. We put up notices at all the pension pay point stations, and we say, if you don't want to be part of this litigation, you have to opt out. So you need to write to the lawyers and say, I don't want to be part of your suit. And unless you notify them that you want to opt out, you are bound by the outcome of the proceedings. So it's very important that as part of that certification process, there must be publication and a notice to people so that they can opt out. Now, what gets two kinds of class actions? An opt-out or an opt-in class action. If I have an opt-out class action, I'm saying, I'm bringing this case on behalf of pensioners in the Eastern Cape. Then we put up notices, all pensioners in the Eastern Cape, notify me if you don't want to be part of this. Unless you notify me, and your claim is similar to the one that I'm bringing to court, you are part of that action. Okay? An opt-in class action is, I put up notices, I say, friends, I've got a suit against the Department of Welfare. This is the basis of my case. Do you want to join me? Then you have to come to me and say, I want to be part of your class action. Okay. But typically, class actions are opt-out. So you catch a whole host of people and you say, if you don't want to be part of it, tell us. Okay, so that's how you try to get to the point of defining who the members of the class are. Okay. Now, in the United States of America, where these things originated, class actions originated, there are very clear court rules and legislative requirements for class actions. So if you want to institute proceedings in the United States of America as a member of a group of people, there are clear indications, this is what you have to do. Now you have to do this, now you have to do that. Now you have to do this, now you have to do that. In South Africa, 20-odd years down the track, we have no rules. What we have is Section 173 of the Constitution that grants a court the authority to regulate its own processes. And what we've seen as a starting process in MUSA is the court taking charge of that process. We don't have rules, we don't have legislation. What we have is the court saying there's a certification stage, there's a dealing with a merit stage. In the certification stage, we need to find out who are the members of this group. How are we going to make it known to them that there's a class action? Okay, so that is the first preliminary step to determine who are members of the group. Okay, now, let's talk about MUSA. The facts we've very briefly discussed. Now, if you look at Judge Vrooman's judgment here in the Eastern Cape Division of the High Court, he emphasized the need for a broad approach to standing. He said there is no point in having a restrictive approach to standing. Because remember now, what was this case about? It was only about standing. Mr. Musa and a couple of other people said, we are pensioners in the Eastern Cape. Our case is typical of tens of thousands of people. We don't know who they are. You, Department of Welfare, you know who they are. We don't know who they are, but we know that our cases are typical. And we want to bring this case in our own name, and then we want to bring it on behalf of this group of people, pensioners whose pension payments were, or Social Security beneficiaries whose security payments were stopped in an unlawful fashion. We are bringing the payment of the action on behalf of this group. The Department of Welfare said, no ways. Not talking about the merits of the case, but saying to Mr. Musa, you can't bring the case on behalf of everyone. Everyone must bring their own cases. And can you see how much cost in court time, in lawyers' time, in a whole host of legal costs that we will see if we have 10,000 different cases. You know who are the biggest crooks in all of this? The lawyers. Because what do the lawyers do? Okay, I'm going to bring a case on your behalf, on your behalf, on your behalf, 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 and I'm going to charge you 10,000, 10,000, 10,000, 10,000, 10,000, 10,000, as opposed to saying, you bring the case, I'm charging 10,000 rand for all of it. Lawyers are the biggest crooks in this, because they see it as a money printing mechanism. So don't be those lawyers. And if you are, just take the Rhodes degree thing and print okay, so Mr. Musa said, I have standing on behalf of the group. The court had to then deal with it. Is it possible to see Mr. Musa as a representative of this entire group? What then happened was that the court said, we have to contextualize this dispute. Where is the Eastern Cape? What is the population in the Eastern Cape, people dependent on social grants? Who are they? Do they all have access to lawyers? Do they all have access to courts? We are talking about people in far-flung rural areas, and the court took judicial notice of the socio-economic circumstances of the majority of people who are in this position where they are dependent on these social security payments. So the court said, this is the kind of case that exactly gives access to justice to the most vulnerable. And we value that. Then the second instance, what the court had to confront, because this was one of the, not one of the things, it was a multiple number of objections raised by the government. The government said, if we allow these class actions, every Joe So, Tom, Dick, and Harry will come and institute proceedings in the interest of a class. We will end up in a litigious society like America, where you, at the drop of a hat, just go run to court and sue people. We can't have people saying, I am acting in the interest of this group, and I'm acting in the interest of that group, and I'm bringing this class litigation. So the first objection the court had to deal with was the floodgates argument. And unfortunately, when this judgment was given, judges didn't number their paragraphs. So you will have to work your way through. If you are using the BCLR reference, I can give you the reference. But if you're not using BCLR, in fact, it's all lies. I can't give you the reference. Because all of the page numbers are exactly not replaced. So, but the court, under the heading, I love the fact that someone's alarm's only going. No, there is no all lies. They are clearly numbered, however. Oh, yes, they are numbered. The objections. The first objection is the floodgates argument. So everyone will come and bring a case before the court. So the court responded to that by saying, if you have busybodies, people who just bring random class actions for no apparent reason, how do you deal with it? You give a costs order against them. You say, actually, my friend, yes, you have the right of access to court and you can bring an assert standing in the interest of a group of people. But if you are wasting our time, you have to pay your costs and you have to pay the costs of the party that you are suing. Attorney and own client scale, and you will see very quickly, people will see, well, actually, it's not the best idea for me to bring random frivolous cases before the court, because I can avoid costs. So the floodgates argument, the court said, the court can regulate that through a cost order, appropriate cost order. The second issue that was raised as an objection is the classification difficulty. So the court says, what is the argument here? The argument is that, how do we know that the case is typical of? How do we know that Mr. Musa's case is typical? How do we know that all the cases are like Mr. Musa's case? And here the court said, when you go to court to certify a class, you must very clearly indicate what the parameters are. You can't go and say, I would like to bring a class action, but I'm not sure exactly how we're going to identify the members of the class and I don't know what the common interest is. Can you please tell the court what the common interest is? The court says no. You have to come and you have to say, we are pensioners and our pensions have been unlawfully terminated, payments. And we, on the basis of that common set of facts, would like to assert standing as a group, and you have to tell us how to proceed with this. So the court says, I can, as the court, control that process to classify the issue appropriately. Now, the third objection is the different circumstances argument. And the different circumstances argument, seen from the perspective of the respondent, is that perhaps my response to cancelling your pension is that you were only temporarily unable to work. And my response to cancelling yours is that you obtained the pension fraudulently. And my response to yours is even something different. The court says, the fact that you assert a class standing and the fact that you bring litigation as a group of people doesn't prohibit the respondent from responding to my case, to your case, to this case, to that case in different ways. So they can say, actually, for this one, this is the defense. For that one, that is the defense. For that one, that is the defense. And there could be hundreds in each of those groups. Okay, so that is the different circumstances requirement, or difficulty. Then the fourth difficulty is the res judicata difficulty. And this is the issue of, if you are in the group and there's an order, unless you've opted out, you are in. Okay? So the res judicata difficulty is that, say for example, I live in the very rural areas where there is no radio signal, no cell phone signal. I very seldom get into contact with people else outside the little village that I live in. It didn't come to my attention that there was a class action. Now I'm bound by the outcome of that action unless I opt out. What if I didn't want to be part of the action? What if I wanted to opt out? Now the court says, once again, this is a matter that can be regulated. You can say, person who is running the class action, Mr. Nuza and the Legal Resources Center, you carry the obligation to sufficiently publicize this very wide. You have to tell people, you have to notify people in the Eastern Cape that they can say, actually, I don't want to be part of it. But the reality is, because the majority of people do not have access to lawyers, the majority of people do not have the finances to have access to courts, this is a saving grace. Because someone is taking the matter on their behalf without them having to actively participate. But they can actively participate if they should want to do so. Because they are notified, they can say, actually, I would like to highlight specific aspects of my case and bring that to the attention of the court. And then the last objection, which the court rejected very swiftly, is the practical impossibility. The practical impossibility argument on behalf of the respondent said, this is just too hard. How can we deal with 10,000 cases at the same time? It's just too difficult. Let's just not. The court says, actually, Sakia, we are the courts and we have to deliver justice to people. We can't just say, it's too difficult, we can't do it. That's not an excuse. Where people have rights, and those rights have been infringed, and there are 10,000 people with the same rights infringement, we can't shrug our shoulders. We have to make it do. We have to provide the class, the directions to the representative of the class so that they can provide the adequate protection of the rights of people. So what we get in Nuza's case is we get the court saying, okay, Mr. Nuza, this is the filing of the order. The court says, Mr. Nuza, you have standing in your own interest and as a representative of the class. But we know that you don't know who those people in the class are. You say that there are pensioners in the Eastern Cape, but guess what? The Department of Welfare, they know whose payments they have terminated. The 9 or 16 or however many departments there were. They know who those people provide you with the information of who those people are, and you must publicize very widely so that people can say, actually, I don't want to be part of your class. Okay. So the court made it very clear that in order to proceed with a class action, there's a certification stage and then there's the merit stage. Sure, this is the third one or the fourth one. Amazing. Tomorrow I'm not seeing one at all. Okay, so the Supreme Court of Appeal was approached because you will not believe it. After the High Court here in Grahamstown did the following, said, Mr. Musa, you have standing in the interest of the class, you may proceed with the matter. If the finding is made, all 10,000 people, we don't know whether it's 9,000 or 11,000, all of them will benefit from the court order. And there will be action taken to realize the rights of people that have been infringed. Now, Eastern Cape Department of Welfare said, no ways. How can you give Mr. Musa standing on behalf of the class? We appeal against the order certifying the class, setting up the class. And Judge Cameron was then in the Supreme Court of Appeal, and he starts very dramatically by saying, the law is a scarce resource in South Africa. This case shows that justice is even harder to come by. So, and then he proceeds to identify important aspects, which I really think you should look at. And it's very oddly numbered, but it is numbered, so I can refer you to the relevant paragraphs. He says that this matter is tailor-made for a class action, and it's paragraph 21. He says, it is beyond issue that the class is so numerous that joinder of the members are impractical. He says, obviously, yes, we can have individual joinder applications from every person. But how long are we going to take if we have to do that? Joinder, the class is so numerous that joinder of all its members will be impractical. The second requirement, he says, there are questions of law and fact common to the class. They were recipients of pensions, their pension payments were stopped unlawfully. Third, the claims of the applicants representing the class are typical of the claims of the rest. And then in the fourth instance, the applicants through their legal representatives will fairly and adequately protect the interests of the class. The quintessential requisites for a class action are therefore present. Okay, so what I want you to be able to understand is that a class action is an appropriate vehicle to deal with a lot of similar cases. But it comes with its own difficulties. And those difficulties are exactly those floodgates, difficulty of managing the case, etc., those 5 that we've gone through. But all of those can be managed. And it is managed through dividing it into a certification stage and a merit stage. And in the certification stage, there must be very clear directive. How are you going to go about to represent the class adequately? Will you publish? Will they opt in? Will they opt out? To make sure that when there is a court order, all 10,000, or 20, or 54, or 209 members of a class have adequate relief in accordance with the rights afforded to them. Okay. So, Musa's case and class actions. And I'm typically going to give you a little set of facts that looks a little bit like Mr. Musa's set of facts. Now I'm going to say to you, Mr. Musa's legal representative, or not his legal representative, because they will be Musa's legal representative, or either you have to advise Mr. Musa as to who's the most appropriate person to bring the matter before the court. And then I want you to explain to me, what is a class action? How do we deal with a class action? How do we proceed? Now, Mukadam's case is a case that had to do with red price fixing. Now, you can go and read Mukadam, and Mukadam is interesting, but Mukadam murks the water a little bit. Because Mukadam's case was not a case under the Constitution. It was a common law action. Now, the court here identifies or acknowledges that even common law standing, where there was sufficient interest in the remedy sought, link between the person approaching the court and the remedy, very clear. The court says, I see see that, but the Constitution, through its radiating effect, also impacts on the common law of standing. So that narrow blinkers that we had in relation to standing under the common law, we have to broaden under the Constitution in respect of all the rights. Now, where Mukadam muddies the water is in the instance where the judge makes an overture remark. What is an overture remark? It's just a remark in passing. He makes an overture remark to say that where someone litigates on the basis of the infringement of a fundamental right, certification may not necessarily be needed. Now that makes it hell of a difference. Because I can go and say, I am litigating on behalf of all lecturers at universities in South Africa. And if the court finds that there's a common set of facts and a common, they can just certify the class. Or they can just say, yes, you have standing. As opposed to setting out a process as to how are we going to advertise it? How are we going to determine who wants to be in and out? How are we going to proceed and say, lecturers are in law faculties at South African universities who teach X, Y, and Z. Otherwise, it becomes unwieldy, and those floodgates arguments and the practical impossibility arguments really become a reality. So Mukadam, in passing, the judge said, well, certification may not necessarily be needed in human rights abuse cases. But I think in all cases where you have a class, you have to first of all go to court to determine who are the members of this class. And once you've determined who are the members of the class and how are we going to manage this? Because even if you have 10,000 people, there may be 2 or 3 people with very particular views, and they want their views to be reflected before the court. Okay. Now, the Legal Resources Centre they continue their work in respect of class actions and representative actions, and particularly in relation to educational rights in the Eastern Cape. Now, I think you are aware of the fact that there are many schools that are substandard, mud structures, no electricity, no running water, and in many of these instances, the Eastern Cape Department of Basic Education had to deal with the matter in the form of a class action, where the Legal Resources Centre represented children and parents and teachers and school governing bodies in an attempt to get appropriate infrastructure in place in school. So this is ongoing and a very efficient way of dealing with this, because instead of having 20 different litigation sets going on at the same time, you have one. But the members of the class are 20 or 50 schools. All right. Now, this is a little bit more complicated. And here, I would like to advise you to don't explain this to your mother, unless your mother is a lawyer, or your grandmother. I want you to tease out the principles. The public interest is wider than the interest of a class. I think you will agree with me. Because if I go to court and I say, I'm acting in the public interest, what I'm actually saying is that everyone in this society has an interest in this matter. But how do I do that? How can I assert that what I'm bringing to the court is actually so important that the court should listen to me in relation to the particular instance? Now, the court in Lawyers for Human Rights identified that the basis here is definitely wider than in the instance of class action. Because what you are asserting here is public interest standing, the court says, is given in addition to those provisions that allow for actions to be instituted on behalf of other people than on behalf of the class. They are wider. Now, in order to bring an action in the interest of the class, in the interest of the public, you have to assert 2 things. And this was set out in the case of Ferreira by Judge Reagan, and it was confirmed in Lawyers for Human Rights. And the 2 requirements are the following. You have to show that you're acting in the public interest and that the public has a sufficient interest in the remedy values. the public interest, and the public has an interest in the requested remedy. Now this is very difficult. And you remember our friend Mr. Glenister. Now Mr. Glenister said, I'm acting in the public interest. And the court, because standing was not contested, very readily accepted that. But it is also possible that if I go to court and I say, I'm acting in the public interest, that the opposing party will say, you're right, you're acting in the public interest. Then I have to convince the court, before I can start with the merits of the matter, that I am acting in the public interest. And here the court has identified those factors, and this is the part where I'm asking you not to engage with this as an intelligent layperson, but as someone who can identify the factors. What are the factors? Is there another reasonable and effective manner in which the challenge can be brought? So is it possible to identify X or Y with a right directly affected? Can we look at category A, category B, category C, or category E? Or is this the most appropriate and reasonable in the circumstances to assert standing on this basis? In the second instance, what is the nature of the relief sought? If we are looking at relief that will benefit a small group of people, we're not talking about the public interest. We are looking at legislation being declared unconstitutional because the legislation aims at protecting people against corruption. And if that legislation is inadequate, well, the entire society suffers as a result of that. The extent to which the remedy is of prospective and general application. If the remedy is not of general and prospective application, then obviously we have to think, well, this is actually perhaps not suitable for a class action. What do we mean by prospective? Forward-looking. Damages, an award of damages is backward-looking. I was called names. I suffered as a result of a breach of contract, so you pay me money, which makes me better about what happened in the past. But a forward-looking remedy is one that remedies it for the future. So prospective and general. So it doesn't single out me for receiving 10 or 20,000 rand. It is general and prospective in application. The range of people or groups of people directly or indirectly affected by the court order. Who are these people that I'm purporting to say that I'm acting in the public interest? But who are the people affected? Is it a small group of people? Is it the general public who suffers as a result of corruption? Is it a group of immigrants? Lawyers for Human Rights is a case about immigration. And the opportunity of persons to bring information before the court. Now this is also very important because if I purport to act in the public interest, I think you can see that it's a very useful tool. You can have the Glenisters of the world and you can have a variety of other people who act in the public interest and bring really important things to the attention of the court. But it is also quite presumptuous to say, well, I, better than anyone else, can do this matter in the public interest. Okay. And then in the second requirement is you have to show it's not about you. It's about the public that has an interest in the remedy that you seek. And this is very important because it shows that when we talk about constitutional litigation in the public interest, we're talking about something that is not only my right. It doesn't only affect me, but it affects the broader members of the public. And that's why Glenister's case is a really good example of a case where the court very swiftly dealt with the issue of standing. It wasn't really contested. Because Mr. Glenister could clearly show that, well, yeah, we could probably find other people to do it, but this is a reasonable way to proceed with the matter. The nature of the relief is broad, because it will result in declaration of invalidity. That law will not be applicable. It has to go back to Parliament. There's not a separation of powers issue. It's general and prospective. So work through that when you look at the different factors and tie it to the particular cases. And there are very few of public interest litigation that we have as examples. Okay. Now, one doesn't necessarily have to assert standing on all bases. If you look at one thing that I just want to add here, Judge Taku, the Lawyers for Human Rights, adds the vulnerability of the group involved. He says a group like immigrants are really vulnerable. And if we can look at the vulnerability of that group and we can assess whether they themselves are able to bring the litigation before the court, that is a factor that we have to bear in mind when we determine whether a person can act in the public interest or not. All right, this is very interesting, but it's broad. One has to address all of those factors when you try to convince the court that you are acting in the public interest. Now, I'm not going to, associations acting in the name of the members, I need to talk about this, and I want to talk about this as well. But I want to rather look at the questions. I'll leave you with the questions, and we'll go back Thursday next week to talk about this. But this is the type of thing that I want you to be able to do. Okay, this is the case of why. Why is a plaintiff in a civil matter instituted a claim for damages? Are we talking about the infringement of a fundamental right? No. So Section 38 is not applicable directly. Okay. He wants the court to develop the scope of the actu in Uriarum in the light of the Constitution to accommodate this case. He says it will be in the public interest. He doesn't need to assert standing. If he wants to claim damages, there's a direct and sufficient interest to be given the remedy that he seeks. And he can assert standing in his own name, but he can ask the court to consider the radiating effect of the Constitution, not on standing, but he needs to ask the court to consider the radiating effect of the Constitution on the development of the common law. Section 173 and Section 8.2 and 8.3 and 39.2. Okay. But the next question is more to the point. This is probably a nasty little trick question, which I shouldn't ask. X is the chairperson of Concerned Citizens, an NGO involved in environmental matters. It came to the attention of the group that the government approved the building of a national road in a nature conservation area. EIA is an environmental impact assessment. The association wants to stop the building of the road. Would they have standing? An allegation that a fundamental right in the Bill of Rights has been infringed demonstrates sufficient interest in the remedy that you seek with reference to the page. Those are your general requirements, and then you have to fill in the details. I think closer to your test will be up to here. I won't ask anything about associations, because we haven't done associations. But your test will be up to here. Your test is Thursday next week. It is!